All right, here's state number 6, Colorado. Yes, I know I haven't finished California. It hurt, and I don't want to right now, okay? I'll do it later. Please don't make me do it right now. I don't want to. I've broken the analysis here down into 9 categories. You can check the description for timestamps if you want to skip around, but I'm going to try to keep it brief enough to where it's easy to sit through the whole thing, and at the end, I'll be giving the state a grade. If you like this sort of content, do me a favor and like the video and subscribe to the channel. It lets me know what kind of content to focus on, and it's also just a nice thing to do that I appreciate very much.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
So first, let's take a look at Colorado's state constitutional right to arms, and we'll keep it in mind as a backdrop for when we go through the rest of the topics. Article 2, Section 13 of the Colorado Constitution provides that the right of no person to keep and bear arms in defense of his home, person, and property, or in aid of the civil power when thereto legally summoned, shall be called into question. Sounds pretty good, right? Well, there's a big but. But nothing herein shall be construed to justify the practice of carrying concealed weapons. Okay, that's kind of weird. It specifically dumps on carrying concealed weapons, rather than other weak constitutional provisions we've looked at before that focus on the means and manner of bearing arms. Now, before we get going, I've just got to say we'll be talking about Denver quite a bit. Denver is a bad place, and its government is made up of bad people. Despite its relatively strong wording outside of the carry sphere, this constitutional provision has been interpreted by Colorado courts to allow a great number of different gun restrictions. For example, in the 1994 case of Robinson v. Denver, gun owners challenged the constitutionality of a Denver assault weapons ban. The trial court found that the city did in fact violate the fundamental right to arms guaranteed by the Colorado Constitution. On appeal, though, the Colorado Supreme Court reversed the trial court's decision, writing the following. While it is clear that this is an important constitutional right, it is not equally clear that this case does not require us to determine whether that right is fundamental. Rather, we have consistently concluded that the state may regulate the exercise of that right under its inherent police power so long as the exercise of that power is reasonable. In doing that, the Supreme Court of Colorado questioned whether or not the right to arms was fundamental at all, as violations of fundamental rights are given more scrutiny in Colorado. This effectively subjected gun regulations to a freestanding balancing test where the government can get away with more or less whatever they want, as long as it can convince a few lawyers wearing dresses that the restriction was reasonable. On remand, most of the offending law remained intact. It's also interesting to point out that Colorado law had a supremacy clause applicable to firearms until 2021, and yet the 1989 Denver assault weapons ban lingered. Curious. As time went on, an attempt was made to have Colorado courts revisit the analysis in cases covering the state right to arms. In the 2014 case of People v. Cisneros, the Colorado Court of Appeals chided that it saw no reason to speculate that our Supreme Court would modify its holding in Robertson in light of Heller. I could only find 2 times that the Supreme Court of Colorado used its constitutional provision to overturn a law. The first was the 1936 case of People v. Nakamura, where the court struck down a law that prohibited unnaturalized foreign-born Coloradans from owning or possessing firearms. In that case, the court opined that the legislature cannot disarm any class of persons or deprive them of the right to bear arms in defense of their home, person, or property. Under this constitutional guarantee, there is no distinction between unnaturalized foreign-born residents and citizens. Many years later, in the 1972 case of City of Lakewood v. Pillow, a city law banning the possession or use of any deadly weapon outside the home was overturned as overbroad. Interestingly, a few years later in People v. Ford, the Supreme Court of Colorado also overturned a prohibitions of firearms possessed by certain felons because it excessively eliminated their right to self-defense. In an attempt to counter the state's highest court's decision that the right to arms may not be fundamental, Colorado law now provides that the state constitution protects the fundamental right of a person to keep and bear arms. As of yet, this part of the law has not been interpreted by the Colorado Supreme Court. But it's another bittersweet thing, as we will see to be the case often in Colorado, as it came as part of a law affirming the ability of local governments to make restrictive gun laws, among other things. So now let's talk about restrictions on owning firearms. This is, if you ask me, the most pernicious class of gun restrictions. These are prerequisites on owning a gun at all. This section will be limited to run-of-the-mill pedestrian firearms like handguns, shotguns, and rifles. State restrictions on NATO guns that the feds like to regulate will be in the cool gun restriction section. To start off, Colorado has no law requiring gun owners to get a license. Furthermore, Colorado does not require the registration of firearms. In fact, state law prohibits local governments from making lists of firearm purchasers or records of guns transferred or left for repair. The Colorado Bureau of Investigation, isn't that cute, the CBI, they must deny the transfer of a firearm if it would violate federal or state law if the transferee meets any of the following criteria. If it would violate federal or Colorado law, as we already said, if the transferee has been arrested or charged but not necessarily convicted of a crime that could prohibit him from having guns under the law, if the transferee is the subject of an indictment, information, or felony complaint alleging that he committed a crime punishable with a term of more than 1 year. A person is also prohibited if they have been convicted of any of the following crimes after June 19th, 2021. Third-degree assault, sexual assault, unlawful sexual conduct, child abuse, violation of a restraining order, a crime against an at-risk person, harassment, a bias-motivated crime, animal cruelty, possession of an illegal weapon, or giving a gun to a kid. Of course, people subject to red flag orders are prohibited from purchasing or possessing firearms as well. The 2021 law also prohibits the possession of firearms who have committed other certain felonies or have attempted to commit them in any state, or if they were adjudicated delinquent as a child for a crime that would have been a felony as an adult. If you do own a gun and you have reason to believe that it has been lost or stolen, you must report the loss or theft to the cops no more than 5 days after you believe it. The law works similarly if you find a lost gun, so apparently Colorado is not a finders keepers state. Within 5 days of receiving this report, the cops must enter the information into the Colorado Bureau of Investigation Crime Information Center database. As for age restrictions, Colorado generally prohibits people under 18 from possessing a handgun unless it's for specific purposes. There is no minimum age to possess rifles and shotguns, nor any state-imposed minimum ages to purchase. With regard to mental health prohibitions, Colorado has many more prohibitions than are the case under federal law. They include orders for short-term treatment of mental illness, extended certification for treatment, and those ordered for long-term care. Some of these can be alleviated upon request after 3 years or if the court has reversed its position on a finding of incompetence. However, there are some instances where it cannot be. Now on to purchase restrictions. This section is for laws that restrict how an individual can acquire a firearm. While federal law controls FFLs, it does not control how individuals inside of a state can transact privately when it comes to firearms. This leaves a lot of latitude for states to either respect or severely frustrate the rights of their residents, and here, of course, Colorado lets us down hard. The state requires almost all firearms transfers between non-dealers to be processed by an FFL, with a category of law often referred to as a universal background check. If you are transferring a firearm to a business or other entity, well, then everyone who is part of the business and authorized by that business to possess a firearm must also have a background check. Dealers are able to charge you a fee of up to $10 for the privilege of having your background check run in these state-required checks. The transferee cannot take the firearm until the CBI approves the transfer, and it must be completed within 30 days of approval. So no automatic proceeds here. The following limited circumstances are exempt from these requirements. These include bona fide gifts or loans between immediate family members, transfers that occur by operation of law or through inheritance, temporary transfers to non-prohibited people that are necessary to prevent immediate grave bodily harm, temporary transfers at shooting ranges, target competitions, or hunting, as long as everything else about the hunt was legal, transfers made to facilitate the repair or maintenance of the firearm, temporary transfers where the owner is always present, soldiers who will be deployed overseas within 30 days of that transfer, so long as it is given to an immediate family member, which seems kind of superfluous, and temporary transfers for up to 3 days. But in the case of a 3-day transfer, the owner will be liable for any damages caused by the recipient's unlawful use of the firearm. If you violate any of the requirements we just discussed, it is a misdemeanor and you will be prohibited from possessing a firearm for 2 years. As far as dealers go, state law requires gun dealers to post a visible sign stating Colorado's prohibition on illegal straw purchases. Colorado also requires people who sell firearms at retail to record each handgun transfer with a requirement separate from those ordinary FFL bound book requirements. Furthermore, Colorado law specifically requires all firearm transfers at gun shows to be done through a licensed dealer. That was a long section, and I'm a little upset. As we've discussed here many times, the right to keep and to bear something necessarily includes the right to acquire it. And what is the purest way to acquire something but to make it yourself? One rather scant point in Colorado's favor is that it has no law restricting homemade, 3D printed, or otherwise lawfully unserialized firearms. Now onto ammunition restrictions. Another obvious prerequisite to a real, well-respected right to keep and bear arms is the ability to feed them. Just as a toy without batteries, a gat without gatteries is no fun. The only restriction specific to ammunition in Colorado is a law prohibiting domestic abusers from possessing ammunition in addition to firearms. Now, carry restrictions. Of course, to keep and to bear arms includes bearing them. Of course, this is a point that states cannot seem to understand. Let's start with the better news here. Colorado does not require a license to openly carry handguns or long guns in public, but local governments can prohibit the open carrying of firearms in specific areas as long as signs are posted. Colorado prohibits the concealed carrying of handguns in public unless you have a permit. As far as issuing them, Colorado is a shall issue state, so if you meet the following requirements, the sheriff must issue your permits unless they don't want to, which we'll touch on in a bit. The criteria are as follows. You are a legal resident of Colorado, 21 years or older, eligible to possess a firearm, not convicted of perjury on a handgun permit form, are not a chronic user of intoxicating liquors, or if you were, you have an affidavit from a therapist saying that you've been refraining from drink for 3 years. You are not a user of the bad drugs. You are not subject to a red flag order, a permanent protection order, or temporary protection order, and you have demonstrated competence with a handgun in a state-authorized manner, which cannot be online. Even if you meet all of these criteria, the sheriff can deny your permit if he has reasonable belief that your documented behavior makes it likely that you might be a danger to yourself or others if you do get a permit. Colorado permits are good for 5 years, and to renew, you must submit an application with the same information as the original, largely, including your fingerprints. 6 months after expiring, the permit cannot be renewed, and one must reapply for a new permit. Local cops must keep a list of people to whom permits have been issued and may share this information with other non-local cops to verify whether your permit is good. State law prohibits the use of this information to create a statewide database of permittees, which I'm sure they never do, not even a little bit. Permits from states that recognize Colorado permits are recognized in state if the person is 21 or over and either a resident of the issuing state or a resident of Colorado for no more than 90 days. On top of this, sheriffs can issue temporary emergency permits to carry a concealed handgun to someone who the sheriff has reason to believe may be in immediate danger. The requirements are similar to the regular permit, except you don't need to do a training and you only need to be 18. It lasts for 90 days unless you're under 21, in which case the sheriff may renew it until you reach 21. As far as where you can carry your heater, Colorado has fairly wide range of off-limits locations. For one, schools are a no-go, whether the gun is loaded or not, including universities with very few exceptions. Some of the exceptions to the campus carry ban include presenting an authorized public demonstration of it, being an employee that requires a weapon at shooting events, and possessing it in your dwelling or car. Speaking of cars, if you're considering getting into one, you better make sure your rifle isn't chambered, as Colorado law prohibits firearms that aren't handguns from having a loaded chamber inside of a motor vehicle. Aside from that, you can carry a concealed firearm with or without a permit in your private automobile for lawful protection while traveling, and local governments aren't supposed to mess with you, which I'm sure they never do, ever, at all. Now, snowmobiles are a different story, for whatever reason, probably some stupid hunting thing. The state prohibits you from operating any snowmobile with a long gun in your possession unless it's unloaded and in a closed case. This applied to handguns as well until March of 2020. State law prohibits anyone from carrying a handgun in a public building that uses screening devices permanently installed or in any public transportation facility without special permission. Not the worst we've seen, but a far cry from the best, I think. Now onto self-defense regulations. Self-defense is an interesting thing to discuss in this context, as it's not super specifically gun law, but a closely related and all too constantly shifting area of the law spawned from our natural right to be secure in ourselves. The thing to understand here is that the law was always designed to protect the innocent actor, the reasonable person who did not acquire a dangerous situation. Over the years, courts began imposing a duty to retreat whenever somebody was attacked outside of their home. The logic being that somebody who could have possibly maybe escaped a dangerous situation didn't necessarily possibly maybe have to use lethal force. This is, of course, insane because the innocent actor did not choose the situation to begin with and thus should not be forced to take particular actions to ensure that their body is not disintegrated. To address this, states began passing what are colloquially referred to as stand your ground laws to correct these courtroom cock-ups. Colorado is not one of these. Now, even though Colorado is not a stand your ground state statutorily, the state Supreme Court has held that there is no duty to retreat before using force to defend oneself in public. All right, time for cool gun restrictions. Here's where we'll talk about whether the state stacks stuff on top of the NFA and GCA when it comes to cool guns that the feds make us pay extra special taxes to own, as well as restrictions on salty weapons and magazones. Colorado does not have a law regulating assault weapons, but it does regulate magazine capacity. And remember, there are some local laws affecting this as well. The state prohibits the sale, transfer, and possession of box, drum, or feed strips that accept more than 15 cartridges of ammunition, shotgun tubes over 28 inches, and magazine extensions that enable a total of more than 8 shotgun shells. The state's definition of large capacity magazine does not include lever action tubes, mags that have been permanently neutered to 15 or less rounds, and tubes attached to guns designed only to operate with 22 rimfire ammunition. Large capacity magazines manufactured in the state after July 1st, 2013 must include a permanent marking indicating that it was manufactured or assembled after that date. There are some exceptions, which include people who owned the mag prior to that date and never gave it up. If someone is accused of violating the law and claims to have possessed it before the ban, the prosecution must prove otherwise. Of course, the ban also exempts military and police agents, people who make big mags solely to give them to cops, or others in similar business. Well, what about the really cool guns, right? Colorado generally prohibits the possession of a dangerous weapon, which includes machine guns, silencers, short-barreled firearms, and ballistic knives. Knowing possession of one of these weapons is a Class 5 felony. However, an affirmative defense for this felony exists for cops, soldiers on duty, and anyone with a valid permit and license for possession of such weapon. Terrible, to be honest. Rights restoration now. we've talked a lot about losing your rights, but getting them back is just as, if not even more, important. Unfortunately, except for those limited circumstances that we previously discussed, Colorado law does not have a specific procedure for the restoration of firearms rights. One's only recourse in most cases, it seems, is a pardon from the governor, which I am told in practice are virtually never granted. For certain drug crimes that are prohibiting, Colorado does provide expungements, but again, this is very narrow. This is dreadful and frankly dehumanizing to Coloradans who have turned their lives around and want a means to effectively protect themselves. These act as lifelong prohibitions on these people, and frankly, I believe that their lives are valuable and worth protecting, but it seems the state of Colorado and its governors tend to disagree. We'll now cover the various and sundries before we get to the grade. In Colorado, you could be convicted of a crime if you do any of the following: intentionally, knowingly, or recklessly hand a handgun to someone under 18, know that a juvenile possesses a handgun and do not snitch on them, if you are aware of a risk that a juvenile will use a handgun to commit a crime and you do not try to take it from them, if you sell, rent, give, or allow unsupervised possession of a long gun by a juvenile without the consent of their parents, or if you give a gun to somebody without doing all of the background check stuff that you were supposed to do. Colorado also bans the possession of blackjacks, gas guns, metal knuckles, gravity knives, and switchblades, the possession of which is a Class 1 misdemeanor. These are referred to as illegal weapons. The state authorizes expulsion from public schools for any student who possessed, without proper authorization, a pellet or BB gun on campus, whether it worked or not. Colorado law also requires that a firearm be safely stored when not in use to prevent access by unsupervised children and other unauthorized users. A firearm is considered safely stored if any of the following apply. If you are carrying it or keeping it so close to you that you could retrieve it as if you were carrying it, if it is in a locked gun safe or otherwise locked up so that unauthorized people cannot access it, if it has a locking device on it and ineligible people do not have access to the key, and finally, if it is a smart gun and you have activated the dumb features. A person commits the offense of unlawful storage when one fails to store the firearm as heretofore described, and the person reasonably should know that either a juvenile can gain access to the firearm without the permission of their parents, or a resident of the premises is ineligible to possess a firearm. To facilitate this, every gun dealer in the state must provide each firearm with a locking device and must post notice of the safe storage law requirements. Okay, so let's take a step back, assess, and grade the state of Colorado using the previous states as a kind of guidepost. Frankly, I've not spent much time in the state. I've got quite a few friends there, all of whom exhibit naked contempt for the state's miserable laws. I now see exactly why. Colorado is an inexplicable mess. Much of the state is quite rural, and it's kind of shocking how much control Denver appears to be able to exert over the state at large. Not only in its politics, but its judiciary as well. The state Supreme Court appears to view the human right to keep and bear arms as nothing but a stain on its constitution to be handily dealt with sophistry. It seems Colorado, as a sovereign, considers firearms a privilege capable of being irreparably revoked at a moment's notice without a second thought. For these reasons, I award Colorado a D-. Think I'm wrong? Did I miss anything? Just let me know in the comments. That's it for today, guys. Let me just say I really appreciate you guys watching and subscribing to this channel. It's made a huge difference and it's been a huge motivator for me. I'm really quite humbled. If you want to support me more than that, I'm on Patreon, Utreon, and Subscribestar. I've got benefits like patron-only content, a Discord, and surely there's going to be more to come. This kind of support is going to help enable me to make more content more regularly, which I desperately want to be able to do. There's also a link to Fuddbusters apparel, stickers, and of course the magic ATF ball in the description below. Thank you all so much for watching up to the end and for your support. I'll see you next time, or if you join up on any of those systems, I'll see you on the Discord. Remember, The anti-side has been working long and hard, passing laws and trying to push more policy like this. Anything more than minimum compliance is self-regulation. Y'all take care.